Hi. Just full disclosure. Full disclosure. I am representing two clients currently challenging scheduling of DOI and DOC, and one challenging scheduling in cannabis, which is not that related. I think really looking at this, you kind of need to understand when you're looking at drug scheduling, the Controlled Substances Act first, and its history and where it comes from as not being a rational, science-based, evidence-based policy. And I think it comes clearly stated from John Ehrlichman, assistant to Nixon's domestic affairs, where he said, you want to know what this is really about, paraphrasing, we knew we couldn't make it illegal to either be against the war or black, but by getting the public to associate hippies with marijuana and blacks with heroin, we'd be able to criminalize these communities and disrupt these communities. And we see a policy going forward here from the adoption of the Controlled Substances Act that really doesn't align with any sort of sound policy, sound science. The Controlled Substances Act breaks down drug scheduling into 5 classes. The most severely restricted class is Schedule 1 substances, which include drugs like heroin, LSD, psilocybin, all the way down to Schedule 5. Schedule 2 includes, these are supposed to be ranked also from based upon accepted medical use, potential for abuse, and accepted safety of use under medical supervision. Like I said, the first ones, you got heroin, LSD, psilocybin. Then we go down to less dangerous substances like methamphetamine, cocaine, fentanyl, obviously being sarcastic. Schedule 3, we got ketamine, and then Schedule 5, the least likelihood of problems with these, we have benzodiazepines, which anybody knows has tremendous problems regarding addiction and withdrawal. The route to scheduling is the DEA can, Congress can either legislatively schedule a drug, and the DEA can petition to schedule a drug, and an interested party can schedule a drug, including pharmaceutical groups, but also too, even an individual citizen can petition the DEA to schedule a drug. The DEA will request that the Department of Health and Human Services conducts what's called an 8-factor analysis assessing the risk, addiction, potential abuse as occurring. HHS will make a recommendation. Then the DEA will publish in the Federal Registry for comment, and there'll be a 30 to 60-day comment period, during which time a party can request a hearing to contest it. If there's no hearing, then it moves forward to publication in the Federal Registry and gets added as a controlled substance. The DEA's had a trend towards shifting towards adding substances to Schedule 1. Over the past 15 years, they've rapidly kind of increased the number of drugs that they're adding. This has a significant impact on research because once a drug becomes scheduled, you have to apply to the DEA to get a license to research it. This increased cost. It's restrictive also. The DEA is not required to grant a license to research this, and it also makes it impractical to research drugs that are non-commercially oriented, and pure academic research is hurt by the scheduling. Also, the cost of obtaining a Schedule 1 substance, if it is obtainable, becomes much more difficult and expensive, and a lot of contract manufacturers are not inclined to manufacture a Schedule 1 substance. In 2022, the DEA moved to Schedule 5 obscure research chemicals, tryptamines, add them to Schedule 1 status. these substances were currently being researched by several different companies. There's a large amount of outcry against this, over 600 published comments about this. And it brought a lot of attention to the research chemical kind of underground community that uses these substances that are similar to controlled substances but aren't scheduled themselves. The DEA trying to schedule these 5 tryptamines that are also being currently used for investigating medical treatment raised a lot of attention. There was a pushback against it by attorneys, and who challenged it, saying that the research they were relying on was outdated, and the DEA withdrew their attempt to schedule these things, which really shocked people because this was one of the rare times we've seen the DEA actually get vested. Move forward to the Analogues Act. If we, it would be nice if there was an option rather than scheduling. There's emergency scheduling, but it's problematic also because it removes the drug placed in Schedule I status. Is there's an option in addition to the Controlled Substances Act. We have the Analogues Act. The Analog Act defines the substances substantially similar in structure, substantially similar in effect with Schedule I or II controlled substance, or if a person represents or intends to represent the drug as a substantially similar effect, it's treated as a Schedule I controlled substance then under the matter of the law. The problem is substantially similar doesn't really have a basis in science or chemistry. It's a vague term. And it's based on this flexible standard notion that they would allow for a broad interpretation of the law to be able to capture a wider group of substances, with the fear that all these new designer drugs were being created that the public was going to be faced with. Destruction of the Act's incredibly poor, the construction of it, and it's not clear whether you have to have a substantially similar effect, a substantially similar structure, and whether it has to be and or whether it's or. So you can find strange situations under the Act where it's very vague as to what might or might not be illegal, and it's virtually impossible to know what is or is not illegal until a jury renders a verdict, because the courts have said that this is a question of fact left up to a jury. So until a jury renders a verdict of whether this is substantially similar in structure or effect, or the person's intent, we can't really know whether it is actually an analog under the Act. Sometimes these are read in a disjunctive way, where only one of those factors is considered. Is it substantially similar in effect? And if you evaluate it based upon that, you can come up with some really aberrant results. Also, too, looking at the person, whether they represent it or to intend to have a similar effect to a Schedule I or II controlled substance, can create some really interesting situations too, where there was a conviction for somebody who took baking flour and candle wax, combined it together, and said this is, and represented it as crack cocaine as a counterfeit drug, and were charged and convicted under the Federal Analogues Act because they purported that it had a substantially similar effect to crack cocaine, even though it was candle wax and flour. This bizarre situation we're in with the law leads to situations where also too, what if we have a chemical that is substantially similar in structure to a Schedule I substance X drug, but has an effect that is substantially similar effect to a different scheduled drug? It could still be a conviction under the Analogues Act. Then you come to the question of when there's sentencing guidelines where you have one drug that has 10 years and another drug that has 20 years, do we go with, is it substantially similar to Schedule I or substantially similar in effect to the other drug, which has the lower sentencing guideline or more? So it just creates complete chaos, and we have a situation where we can have jurisdictions where we have a jury in the same jurisdiction come up with saying this is an analog, another one that says it's not an analog, and complete chaos with that, where you can have it being acceptable, and the courts have ruled that this still does not violate vagueness under the Constitution. I'm out of time, but thanks. Questions?
Do you see any sort of legal pathway of showing through scientific means for descheduling, or is that sort of off the table with the language of the Controlled Substances Act?
Descheduling is always a challenging matter because the way the DEA has interpreted scheduling, they pretty much said they've reduced it down from, for Schedule I substance, analyzing safety of use, addiction potential, and accepted medical use, which they defined accepted medical use to mean that it's an FDA-approved drug. They basically have stopped the analysis at, is it an FDA-approved drug? If it's not, it's a Schedule I controlled substance as far as the DEA is concerned. I personally hope that some of the changes with challenges to the administrative law and its problematic, the viewpoint that the court's taking regarding some administrative agency power in this particular circumstance, I think it could be a positive and could potentially open up a door there. Go ahead.
I was intrigued by the point you made about the jury question nature and the substantially similar analysis, but then also the ambiguity about what it means. I'm curious, there are model jury instructions on the subject, and then also how often this actually gets to be litigated, because you might imagine that, if you don't know what substantially similar means, ex ante, that's a very strong disincentive to actually make anything that gets close.
I believe there are model jury instructions. I can't say without certainty, and I really don't have any information regarding statistics, but that's an interesting point to look into, definitely.
Eduardo.
So today we talked about cognitive liberty as one human right that is fully understood. And there's another one, which is the right to enjoy the benefits of scientific progress. It's included in the Universal Declaration of Human Rights. I would like to know your opinion on drug scheduling, if it violates or not, if it violates, how it violates the right to science.
I guess part of that would come down to kind of how seriously the U.S. accepts international law and to kind of be in alignment with it, which I have questions myself regarding that. I think that I think the entire process, the way it's structured, is the entire scheduling thing. I think criminality as an approach is inherently flawed. I just don't think it's effective. I don't have a great solution to it other than education, harm reduction, safe access, things like that. But the entire criminality approach at all, and then the classification of the drugs is just insane. I mean, the fact that cannabis is Schedule 1 and methamphetamine is Schedule 2, it's just bizarre. And psilocybin too, and also too, just the analysis, also too, the way it's interpreted too. Potential for abuse is just misrepresented. I mean, psilocybin does not have an incredible potential for abuse. It kind of, has the opposite in many ways.
Can you say a little bit more about what is at stake with sort of overzealous utilization of the Federal Analog Act? I mean, what are the stakes, and why should we be concerned about it with respect to psychedelics?
Oh, absolutely. I think the matter that I'm working on, without going into too much detail on the specific strategy or anything, is the scheduling of DOI DOI is a drug that the government, states that there is no evidence whatsoever of human use, other than the only facts they put forth as evidence of its human use is Arrowhead trip reports and Reddit reports, which is, I don't know, are Facebook comments coming next as evidence? But this is the case there. We have a drug where there's no evidence of its abuse. It's not being sold. It's not being commercially available in the underground. It's cited in over 900 papers, and it's the last unscheduled 5-HT2A agonist available for research. And it's about to get taken off of the table for no reason I can see whatsoever. And the fact that, this is a kind of, my understanding from chemists is a kind of a benchmark for measuring serotonergic response in that receptor. And it has, for classical psychedelics, it's incredibly important. And that's just being, I don't know, I would argue arbitrarily and capriciously removed, is something, I honestly wish more people in the scientific community and legal community were upset about.
For those not super well versed in the scheduling process, the bar to place something in Schedule 1, for example, the amount of evidence required is often very trivial. So, you were joking when you were saying social media account or Arrowhead reports being used to schedule, but in reality, that's actually not that far from the truth.
No, that is the actual truth. They are citing, literally Arrowhead reports in the Federal Register. It's surreal.
You can contrast that. So the amount of evidence required to put something into Schedule 1 could be calls to poison control, some social media posts, whereas the barrier to take something out of Schedule 1 is very, very different and a much more rigorous, robust amount of research.
As we're seeing with MDMA, it's once it's there, it's much more difficult to get back. And what the evidence is, and also too, they don't even have to show that there is actual abuse. It's potential for abuse, which is a real problem, because this is just, in my opinion, it's excessive. And also too, we're having an administrative agency that's basically creating new criminal law, because each one of these criminalized substances now is, there's a new, quasi-criminal sort of statute there that substance being added there that a person's being tried and convicted under, and that just being kind of delegated to the DEA. I just think is too far.
Additional questions? I think after we hear from Leonard, I might have more to say, kind of combining your two papers, because I've seen AI utilized in combination with the Federal Analog Act to aid the scheduling of substances. So I'm going to comment a bit on that afterwards. All right, well, thank you very much. Next, we're going to hear from Andrew Gilden, Associate Professor of Law at Willamette University College of Law, and Sarah R. Wasserman-Rajek, Professor of Law at William & Mary Law School, discussing psychedelics through a patent lens. Welcome.
Thank you. So thank you to the organizers, and thank you to all you participants. It's been really an interesting conversation for us. And we're taking a slightly different perspective on psychedelics, which I think will then be also complemented in the last session with a discussion of patents as well. So where do we have that? Yeah. Okay. Okay. So patents is sort of the lens we're using to look at psychedelic development. Patents are generally tools to promote innovation. They give an exclusive right, and it encourages innovation because people want that 20 years of exclusivity. They can charge higher prices for their goods during that time. But there's more to patents, right? So there's a balance. And the other side of the balance is that after 20 years, the inventions drop into the public domain. And in addition, there's a disclosure theory of patents that says, one of the benefits of patents is that we get information about things. So in addition to getting this innovation after 20 years, we actually learn about it immediately, 18 months after application it gets published and when it gets issued. And so there's required disclosures when you file a patent. The patent applicant has to show how to make and use an invention so that others can do it. They have to give clear boundaries so that others can avoid it or license it if they want to. And they also, they have to show how it's new and how it's non-obvious. They also have to show the utility of the patent. So there's a requirement that inventions be useful. And so our work uses this requirement that patents have to explain their utility and builds on the insight that others have had that patents are expressive documents to analyze the way that people describe their inventions. So we leverage this to study social norms surrounding and the understanding of innovation at the time that patents were filed. And in particular, we've done this with technologies that aren't characterized by transparency in general. And for technologies where the utility is really tied up in ideas of social values. So for example, an early case about patent utility had to do with water pumps and whether somebody could get a patent on a new water pump that pumped water, but not necessarily better than the other pumps out there. So that was an early utility case. That's not the type of patent that we've been looking at, the type of innovation. Instead, in the fields that we've been studying, there's a contrast between how the patent system is meant to push this disclosure and transparency and fields where for reasons of morality or legality or just general social acceptance, there's not much transparency at all. And so in our previous paper, we talked about taboo technologies. So it doesn't precisely fit taboo technologies. And in part as a nod to how some of these technologies have developed in indigenous or other subcultural communities. So we've done this with patents on, we've done this on patents on devices that bring sexual pleasure and found that the descriptions of the utility of those devices, their purpose, were heavily influenced by developing social norms over time. And that area is sort of the longest timeline I think that we've looked at. We've also looked at patents on abortifacient technologies, and sort of parallels with abortifacient technologies have come up a couple of times today. And we found that patents serve as a rich source to track the progression of technologies from the margins of society through introduction into the mainstream marketplace. So our methodology for this has been to pull patents in the field. Our original project included cannabis as well, which has a bit of a longer history in terms of patenting and entry into legality. And we reviewed the background statements of each of the patents that discuss the utility. And we recognize there's multiple audiences for this, right? There's a patent examiner you're trying to convince, there's investors, and others, but we've analyzed how things are described. We use Google Patents to search granted US patents whose abstract contained at least one of the following terms. We included cannabis, cannabinoid, marijuana, but also for this project, psilocybin, psilocin psychedelic, and MDMA. And we've, in the grander search, we got over 1,000 results. And then we closely reviewed a randomized representative sample of these results. So there's been a big uptick since 2020 in patenting activity around the therapeutic use of illicit drugs and psychedelics. We looked at 20 patents that expressly disclose the use of them to treat a wide range of conditions and illnesses, including severe depression, obsessive compulsive disorder, anxiety, bipolar, schizophrenia, and post-traumatic stress and various other diseases. So that's the background of it, and I will hand it over.
Okay, so I'm going to do something to dive into this is kind of dive into some of the issued patents. And what we do in the paper in our work generally is to really look at patents through like different rhetorical frameworks. So I'm just going to go through sort of 4 or 5 of them. And again, everything that's up here comes directly from, this is direct quotes from actually granted patents. And in each of these, they're using these kind of rhetorical frames to explain the value of what might be a controversial new technology. So probably the most familiar one is the therapeutic framework, where the value of the disclosed substance or method comes from its ability to address some pre-existing medical condition. It could be physical, like headaches or allergies, it could be psychological. But within the therapeutic framework, the idea is that you're restoring ill people to some baseline level of normalcy. You're not kind of elevating already healthy people to some new heightened state of pleasure or euphoria. Then similar to the therapeutic frame is the idea of a pharmaceutical framework, where the patentee emphasizes that the invention is the product of mainstream research and development, that the medical value has been established through clinical trials, and this is innovation that is not the product of some underground drug scene or part of a kind of religious ritual. And you see kind of an emphasis on precise dosing from the synthetic or isolated compound that would be unavailable with the natural occurring psychedelics. And within the pharmaceutical framework, there's this emphasis that what we're doing here is just the next generation of prescription drugs. Then a slight shift towards what we're calling a wellness framework, where you're not necessarily treating an illness, but you're promoting overall health and wellness. You sleep well, focus more, feel more energized, and perform better at your job or at school or in your relationships. And what we see here is often very explicit piggybacking on the kind of mainstreaming of a microdosing movement in psychedelics, where it's not necessary to treat an illness, but it's also not purely recreational use. If you use psychedelics, the patent psychedelics in this way, you'll be more functional than you were before. Again, the idea here is that introduction of these drugs in society more broadly won't be actually all that socially disruptive. Then we were a bit surprised to see so many patents expressly mention the long history of psychedelics, given that it might undercut the argument that this is a novel invention. But at the same time, mentioning this long history of psychedelic use does signal that we already live in a world where there's lots of psychedelic use. We're not going to, by granting this patent, it won't be significantly disrupted. And also, you're able to more clearly set a distinction between kind of the traditional uses that have been out there and then kind of more pharmaceutical uses that are being patented now. Then one framework that hasn't really shown up in the psychedelic space, but has shown up in the cannabis context, is what we're calling a pleasure framework, where there's an open acknowledgement about the purely enjoyable recreational uses, and these patents take as a given that the goal is to feel good. So the focus on the mention is that it smells a certain way, it gives a particular relaxing or uplifting effect. And then what you see is that the patents start to actually look like marketing pitches. That when you have a saturated market for a psychoactive drug, the way you differentiate yourself is through some of the luxuries and the pleasures of consumption, not through the basic function. We haven't seen this in the psychedelic context yet. There's some amount of recreational use. I'd be quite surprised if the trajectory of psychedelics doesn't continue to mirror what we saw in cannabis, and actually what it reflects in the sexual context or work classes as well, where there's kind of movement from medicine to wellness to pleasure. Just about out of time, but we're going to see that these frameworks are not unique to psychedelics. We've seen them for cannabis, for sex toys, for abortions, and actually throughout the history of U.S. drug policy. This is the way that legalization and criminalization debates have been framed, whether you're dealing with cannabis or opium or cocaine or even alcohol. So there's really a large existing body of critical scholarship, feminists, critical race theory, critical theorists who have really pushed back against some of this framing. The main focus really, there's kind of two main focuses of our critique. One is the distinction between medicine and recreation. A lot of the war on drugs framework is built upon associating certain groups of people with recreational uses, and so saying, okay, if you're on the pleasure side of things, rational use of recreational, actually in the mentioned MDMA scheduling, a lot of the basis for scheduling MDMA was like gay men's basically recreational use of MDMA, or sort of raver culture outside the scope of the doctor's oversight, and that was the kind of evidence of abuse, which is the idea that abuse, basically pleasure and abuse kind of collapsed within the CSA, and we see that basic framework being used here to kind of justify the issues of patents. Finally, at times that also built into these frameworks is kind of the erasure of outsider knowledge, both indigenous and subcultural, and you see oftentimes patents actually really, sometimes they're emphasizing the long history of these uses, other times they're saying, like, oh, these technologies are not advanced at all, it hasn't been done as research, which ultimately downplays a lot of innovation that exists, and ultimately kind of shifts control over these technologies towards those who weren't actually that responsible for innovating in the first place. I think that we're way over, so I look forward to hearing.
Before I turn it over to Robert, I just wanted to say that I think my patent law professor, a colleague of Robert's at Vanderbilt Law School, Sean Seymour, one of the best teachers I ever had in law school, would really enjoy your framing of the patent database as a rich archive of changing social attitudes towards taboo technologies. I thought that was really interesting when I was reading your paper. Robert.
I'm sure Sean is familiar with your work, actually. I am curious as to, if you can elaborate a bit on what's driving this. So Andrew, you mentioned, for example, that it's almost like it's marketing. And I know sometimes you can use that patent pending as a good marketing trick. But if you look at it more clinically, the patent application, all you're trying to do is convince that patent examiner, hey, this has some utility to it. So why would you see sort of a shift across time in terms of how the value of these products might be framed differently? Why would you see those shifts if the objective, at least for patent purposes, is all about getting that 20-year license of exclusivity? Why would it reflect anything else other than just that simple utilitarian task?
Yeah, so I mean, I mentioned, right, there's different audiences. So there is a patent examiner, and you do want to convince them, but you also might have investors. And so you'd also like them to see how you're writing about how wonderful this thing is. I think with our piece on pleasure patents that focused on sexual technologies, because that went back to early 20th century, we were able to see, I think it's because the people writing the patents, inventors and patent attorneys together, they are products of their time as well, right? And so they would write in early 20th century, this is to overcome frigidity in females and strengthen marriage. And you saw the narratives change, and they changed sort of exactly where you think they did. Like, when the AIDS crisis hit, then you got this promotes safer sex. So I think it's a reflection of how people think about what tools they're giving and how they can say what they think the utility of that is.
Yeah, and I'd add to that I think there is a PR strategy that goes into patenting sort of controversial technologies. I mean, one, there is a perception there's a patent pending, which doesn't mean anything except for follow patent. Also, there's a perception that, the government has in some ways put a stamp of approval on this product, which again is not technically true, but it does have that, it does lend some legitimacy. And if the ultimate goal is to go to the FDA and then the DEA, it's a lot cheaper to get a patent. You can start the process of legitimization. So you see, really in all of these contexts, a preview of kind of what is coming next in the law. So whether but you see, let's say in the cannabis context, you have art in the 80s, 90s, and 2000s. You have you have a huge body of patents that are talking about why we should have recreational cannabis, and then medical cannabis, and then recreational cannabis, and you see that like this is sort of often kind of like step one of your broader strategy to normalize and legalize.
Glenn?
First of all, this is so interesting. I guess I wanted to ask about the consistency of frame across multiple patents by the same patent. This is going to have to be anecdotal because you haven't done like the parallel work. But take, for example, something like the Compass patents on their psilocybin patented substance, but also or MAPS' methods of administration on top of the actual substances. Whether you see a lot of consistency of frame across multiple patents in the family, and whether that reflects a single patent author or a single general counsel, or different strategic speech as to the different functions of each patent's portfolio.
Yeah. There is quite a bit of cut and paste across the patent. Usually you're like, oh, I've seen this phrase before, and he's like, oh, it's similar. So I think ultimately what's going on here is a question about why you see these kind of narratives in the first place. I think that there's a decision that, okay, this is the most persuasive way to make this seem like something that should issue. And you can see like some of these frameworks are kind of in contrast in contention with each other. So there is a decision about like, okay, we're going to talk about this long history, and there's the background mentioned doesn't change that much across the different methods in the class. But we haven't done this across the board, but that's just like intuitively that's what it is.
Yeah, and also if the patents are related to each other, if they're continuation in parts, then they can't have a different specification, so then they have to have the same. But I also think once it's issued, like, why would you change it? It worked, right? So yeah, I think you're right.
Lewis?
So, I assume this was a mixture of composition of matter patents and method of use patents. To the extent that we're talking about method of use patents, did you find an incentive to broaden the utility claim? Like, in other words, were the claims less cabined into these categories when it was a method of use patent? Because, you know, you're basically, you know, leaving the patent market to other people. If you, I can't talk patent talk intelligently. Do you understand what I'm asking?
So I think what you're saying is, because what you're describing is use this in this way, do you still have to sort of say for what purpose? You still have to make that utility claim. And you do. You still have to be able to say what it does. Now, anyone who uses it in the way that you've described will be infringing. So you don't have to describe sort of, nobody looks at the utility when they're looking at infringement. It's just about whether you get the patent. So you could describe a pretty simple use, do it for depression, and then if people do exactly the, well, no, that's not true. That's not true. Yeah, so you could use, you can expand some on the use that you've described, but if someone uses that method of use, this many milligrams at this time or whatever, that would still be infringing. So I don't think we see an expansion, although thank you for making me think through that.
Yeah, I would say that you don't need to tell the history of psilocybin to get a patent space. But what interests us about all these areas was the perceived need by patentees to actually narrate some story around the invention above and beyond just like how it's the points of novelty, the sort of basic utility. So if you look at cannabis patents in the last few years, there's very little upfront about like why cannabis is socially or medically valuable. It just says this is a method for a more easily sort of more efficiently burning cannabis, or for improved aroma in cannabis products. So it's like, okay, yeah, that's all it does. This is whatever thing. There's a sense that the market's already there. They don't really need to say that much. So it's interesting to us the fact that they are saying so much more than is legally required, which is why it becomes an interesting kind of cultural archive.
We technically have about 12 seconds left, so I'll quickly go to Logan.
I was just curious about to what degree these frames are sort of driving some of the claims about distinctions from prior art. So like, to what extent is the pleasure claims or even like the therapeutic claims, are those aimed at distinguishing themselves from prior art, or is it purely just persuasive for the patent examiner, I guess?
Usually it's not, because you sort of describe the field of the invention, what the state of the art is, and then how your thing is different. And so the utility description is sort of threaded throughout it, but it doesn't usually. And actually, this goes back to that plow case, or the pump case. Sorry, you don't have to show that you're better than anything else out there. You just have to show you're different. So as long as you're just describing the utility of these things, then you're fine. So it's not usually used to distinguish.
So the only time I can think about it where it maybe make the argument driving a little bit is when it's all about whether like particular dosages or dosing in the prior, and that's where sometimes the idea of focusing on like what we've done is figure out what precise dosing is necessary to kind of fall within a microdose that's still effective. But otherwise, this is much more sort of lawyerly persuasion, sort of setting the scene for the exciting patent analysis that follows.
Utility is almost like a vestigial requirement of patent. All right, well, last but certainly not least, we are going to hear from Leonard Picard, affiliated researcher at the Project on Psychedelics Law and Regulation, POPLAR, at the Petrie-Flom Center. Former research associate in neurobiology, Harvard Medical School, Harvard Fellow in Drug Policy, Harvard Kennedy School of Government, and Deputy Director of the Drug Policy Analysis Program at UCLA. And Leonard will speak to us about artificial intelligence in drug development of psychedelics. Welcome, Leonard.
Thank you, Mason, and good afternoon. It's really lovely to see friends and colleagues gathered here today to discuss a subject that 5 years ago would be anathema to tenure track. It's a real pleasure to see you. We can finally speak a little more freely. In 1996, while at the Case School, I issued a warning on what would be the most probable next drug of use. It was then considered an arcane drug no one had ever heard of, called fentanyl. I presented on this at the Faculty Club of Fellows, at the School of Public Health, the Case School. Considered speculative, science fiction. Of course, now we know otherwise. Today I will issue another warning, not about a specific drug, but about our technology, which will advance, in Rob's case, millions of analogues, millions of analogues. Some marvelous medicines that are deleterious, most of no interest, some quite some little horrors. So we begin with a discussion of epidemics. Epidemics can be either benign, influenza, immunity, for example, or they can be extremely horrific. We'll begin with a benign, arguably benign. LSD, of course, distributed verifiably 1 billion doses since the 60s, possibly 2 billion doses synthesized in clandestine laboratories. The initial primary source was honestly Augustus Stanley III, who synthesized in 66, 67, 5 million doses deployed in Northern California throughout the West Coast. The young Nick Sand dwarfed Owsley's output with a synthesis of 250 million doses. This is the young Nick Sand. The old Nick Sand. Nick Sand and Tim Scully, his compatriot in this journey. A blotter honoring Nicky issued some years ago. And his mentor, Sasha Shulgin. Some of you may have known Sasha and a beloved pharmacologist who invented 400 or 500 tryptamines and methamphetamines in his lovely home laboratory, licensed by DEA. Sashi gave me a sample of 2CB in 1988, one of his first syntheses. This drug arm became a notorious or enjoyable rave drug worldwide. It still presently is. The problem is if you stack several doses, it can be quite difficult. N-bomb is a variety of 2CB invented at the Free University of Berlin by a postdoc there in a long series of homologs. The problem with N-bomb is it's effective at 100 micrograms, so it just was distributed on LSD plotters. There were a number of deaths in India from this. And here's the horror story of the ages. Fentanyl, 100 times the potency of morphine, easily synthesized by a single individual. Carfentanil, 100 times that potency. Janssen created all of these. There's 10,000 analogues of fentanyl. Some are extraordinarily, like 3-methylfentanyl, extraordinarily potent. I proposed in '96 that precursors be controlled, NPP and ANPP, a way to stop this speculative science fiction epidemic in the future. But that was ignored, independently done in 2017 by UN Convention. No comment. Rand Corporation got...
Can you speak into the microphone?
Yes, Rand Corporation got involved in 2019 in the future of fentanyl, other synthetic opioids, and commented on these projections and recommendations for prevention. Gilden is aware of this paper. Dual use may occur in terms of platform computational chemistry methods. Now we're moving from the bench into physics-based molecular design. Dual use may occur. For example, you can instruct a computational program to search for drugs that are less toxic generally. That's how it goes. But you can also reverse that, instruct it to search for drugs that are more toxic. So a dual use program has created a drug related to VX, the nerve gas factor, which is, and 40,000 other related molecules close to VX. So we're on the borderline of a technology that, in the wrong hands, for example, by bad actors, either individuals or groups, either state or non-state actors, are empowered to create molecules which, in the wrong hands, can be extremely detrimental to society. But we're just getting started. Rather than physics-based molecular modeling, they have a three-dimensional molecule, let's say MDMA, that you're fitting into a receptor site and you're rotating on a computer screen. AI is entering the situation and creating new molecules completely from scratch without the intervention or consideration of the human mind. Let's take a little tour of how that happened. Alex Krzyzewski was the turning point in 2012 for the resurgence from the AI winter, like the psychedelic winter went away. Krzyzewski made the AI winter go away in 2012 with the advancement in deep learning. He won the ImageNet competition where machines were given vision, created a form of ML called AlexNet, completely dominated the field of machine vision. Jeff Dean, God to a lot of computer scientists at GoogleX, the moonshot laboratory, put together 16,000 processors, and without teaching the machine anything or programming it, this machine went into the net and on its own autonomously began to learn how to identify initially cats. So the machine not only could see, but could summarize, search, think, and propose the identity of various things that it saw. Ian Goodfellow, each individual that I'm describing is a fundamental researcher that transformed AI very quickly since 2012. Ian Goodfellow, fondly known as the grandfather on generative adversarial networks, learned to put two deep learning networks against each other, kind of a duel. One would propose lots of words or ideas, the other would check those ideas. After billions of iterations, you have entirely new capabilities. Among these capabilities, of course, are GPT and Anthropic's Claude, and all the pleasant little apps that we know today. Ashish Vaswani brought forth the transformer, generative pre-trained transformers, GPT. It was Vaswani that did the transformer, of taking one input and transforming it to a different form of input so we can have large language models. This all led up to DeepMind's AlphaGo, the self-teaching machine by DeepMind in London, in which competed against itself until it became so proficient it defeated the world's leading experts, Lee Sedol, in Move 37, a move that no human would have ever considered, an alien, inhuman move. The machine thought of something no human had come across before. I'll skip this. This is an AI-generated film. Ask me about it. We can look at it maybe during question period. So we're seeing emergent AI come through, breakthrough capabilities in these machines. Swarm intelligence collaborating to solve tasks not explicitly programmed. Unforeseen gaming strategies like Move 37. Applied to drug design, we will see novel molecules created and proposed by a machine that's not even programmed to do that. Hence, we'll see, as the earlier varieties of EX, perhaps even more lethal compounds, more addictive compounds. Biotech's entering the sphere. All of these firms have billion-dollar programs moving toward application of AI for drug design. I'm sorry.
I'm sure you.
Sorry about that. Dennis Asabas at DeepMind is moving into molecular design through biological systems. Alex Zavarenko is head of in silico medicine, which has produced a fibromyalgia drug, completely computer generated from scratch in 18 months, a process that would ordinarily take 10 years and $1 billion. Alex will be here on September 19th at Harvard Law School in a panel with the genomicist George Church. I possibly will moderate that, and we will ask Alex about the application of AI to drug design, to molecules that may reach the underground and be distributed. Alex is moving his world headquarters, now presently spread in Dubai, Shenzhen, and Montreal, to 1000 Mass Avenue. Soon. Approaching psychedelics. I talked to the chief chemist of each of these psychedelic startup firms, Celera, Silo, and Pangea Bio. Both Celera and Silo are doing non-hallucinogenic hallucinogens, discussed earlier today. Celera is not able to have the pockets, doesn't have the financing to build the training models, which can cost $100 million for AI to look at its molecules, so they've abandoned the project. Silo hopes to do that. He certainly has a good grasp of it. The only one actually doing anything with real AI rather than physics-based software is Pangea Bio. They have the chair of informatics at Cambridge, UK on board, Andreas Binder. Let me run through quickly because we are moving out of time here. AI will thoroughly be enhanced even further from its massive application by quantum computing. We're talking about desktop computers using these AI design molecules. We're talking also about silicon-based, von Neumann silicon-based computers such as Frontier, the fastest supercomputer on Earth by far for the last 5 years, that will bridge. Frontier would take 10,000 years to do a intractable task that a qubit quantum computer, Sycamore by Google, can do in 200 seconds. So quantum is merging with AI to advance the power of both communities and research. This quantum computer here is about 6 feet long, and it was made by a friend at the Quantum AI Lab in Santa Barbara. It's mostly a refrigerator down to about an absolute zero. The actual device is located here. But I'm well out of time and must end, except for a call to action. Harvard, Oxford, Hopkins is forming a program on psychedelic ethics that may lead to other drug ethics to address the problems in the future. And the problem of artificial intelligence applied to drug development is a primary issue of concern. Not to say there aren't wonderful medicines from it. It's just that we must not neglect this moment.
We have about 5 minutes for questions. We go to Logan.
Oh, that was up from before. I don't have a question top of mind yet. Give me a minute.
No pressure. Christoph.
Perhaps a very easy question for the humanities scholar. How vast is the chemical space? And I would have thought in the last 50 years of analogues drug design, we have tried out very many avenues already. So how much of that space is unexplored and can be explored?
Well, the chemical space itself is larger than a figure larger than the known atoms in the universe. It's 10 to the 60th possible structures. It's rather vast. We've only addressed an infinitesimal fraction of it with the bench work, people in white coats with glassware, the techniques that we've used since the 16th century. And yet, the epidemics that we just discussed, fentanyl, of course, was developed by that bench work by Janssen in the 60s. And you see the horror, of course, that it's caused worldwide. The problem is that with these new empowered technologies, benign as AI appears to be at this early stage, we inevitably will see millions and millions of variants. This can be tuned either for positive aspects or, as mentioned earlier, rogue actors, state and non-state and serial governments may employ the technology to create new toxins and poisons or addictive compounds. We may see small firms create a new erotic or libido-enhancing compounds that be extraordinarily addictive, kind of pharmacological wildfire worldwide. We'll see genomics used with an AlphaFold mechanism to identify the structure of proteins. Three-dimensional structure of proteins can be developed, also applied to genomics. We'll see drugs that are cognitively enhancing, that are stimulating, that improve learning and memory or attention. It's a brave new world.
I think we have time for one more question, maybe two. We'll see. Robert.
So I'm curious, what's the regulatory response? It's the end of the world scenario. How do we stop that? Because I'm thinking if you can use AI to get around all the capacity constraints on a human chemist, you could also use AI to get around all the legal constraints that statutes currently impose. Design a drug that is not substantially similar to this other one that has identical effects. You're only satisfying one of the two elements of the analog act. So, is there a solution? If so, what is it?
And maximize patentability while you're at it.
Go for broke.
Of course, we expect you to do all of these things. I suppose you could ask AI how to avoid legal barriers and therefore criminality, that sort of thing. But what we're speaking of here really is the generation of the molecules themselves rather than the ethical concerns that perhaps that answers your question.
Matt, very quickly.
Okay. So in terms of the seemingly endless space, chemical use space. I had a discussion with David Olson several years ago about, how many possibilities are there. And he told me something that seems at odds with what you're saying. He said that the limitation on the size of the molecule that can pass the blood-brain barrier posed a substantial limitation, combined with all the stuff that Sasha and David Nichols, synthesized, that, they picked a lot of them off, and so that the space wasn't that big in terms of the possibilities. Do you have any, I had no idea, do you have any comment on that?
Well, the 10 to 60s comment is limited to molecules that will pass the blood-brain barrier. That would be molecules of less than 300 daltons atomic weight, small molecules they're called. But this technology can also be used to apply to materials that will cross the blood-brain barrier, like adenoviruses, carry CRISPR technology across to deep anatomical structures. So we'll see all of the above, small molecule approaches to all of these phenomena, answers, if you will, to actual genetic engineering using the same technology applied to genomics that is applied to small molecules.
Please join me in thanking our panelists.